You may sit up, please.
Respectfully, my lords, my name is Adegboyega Awomolo. My lord, ADEGBOYEGA Awomolo for reference to the appeal court, and may I also identify the affidavit in support. It is only a 6-paragraph affidavit, my lord, deposed to by my younger brother, Prince Emmanuel Kanu, also dated the 12th day of November 2025. There is an accompanying affidavit of urgency, which was deposed to by my humble self, also filed on the 12th day of November 2025, and also a written address. My lord, in support of the motion on notice, praying for the orders I had earlier outlined, that too was dated on the 12th day of November. My lord, may I most graciously ask my lord to grant these prayers. Thank you very much.
What about the other 2 motions?
I should move them at the same time?
Yes.
Thank you.
I've made an order consolidating the hearing of the 3 motions.
Okay. The next one, my lord, is an application, a notice of my commitment to file a final written address, which was dated the 11th day of November and filed on the same 11th day of November. It is accompanied, my lord, by grounds upon which this very application is predicated, and the grounds are 4 in number, my lord, and I went on to elucidate the body of objection and then the constitutional foundation and jurisdictional limits of this very court.
Do you have the grounds stated?
Yes, my lord, you may. Ground number 1, my lord, states here, the defendant, having called evidence through cross-examination of all the complainant's witnesses, has given evidence and entitled to the summation of those points through a final written address. So I have actually entered my defense, my lord. What I did not do is to call a witness, because the evidence tendered by the prosecution were surgically demolished. The right to grant to, my Lord, the right to final address is a fundamental constitutional right integral to fair hearing under Section 36, Sub 1 of the 1999 Constitution, and no court has jurisdiction to unilaterally order its waiver without the express, informed, and voluntary consent of the right holder, which is myself. The third ground, any order directing or implying a waiver or final address constitutes a breach of fair hearing, my Lord, which goes to the root of the court's jurisdiction and renders the entire proceedings a nullity. The court, ground number 4, the court lacks jurisdiction to extinguish or dispense with mandatory procedural stage of criminal adjudication, such as a final written address, as this would amount to an unlawful assumption of power beyond the limits prescribed by the Constitution and extant laws. And ground number 4, for reference purposes, my Lord, Section 36(1) of the 1999 Constitution, which I'm sure the court has taken judicial notice of. Those are my grounds, my Lord, in respect of the notice seeking this court's discretion to allow me to file my final written address. Having entered my defense, I move that this very notice be adopted, my Lord, in its entirety. The third and the very last one is the issue of bail. My Lord, the issue of bail. This was dated the 17th day of November 2025 and filed on the 17th day of November 2025. It's a very simple one. It is a notice, my Lord, brought pursuant to sections 35(1), 35(4), and 36(12) of the Constitution of the Federal Republic of Nigeria, 1999, as amended, sections 158, 162, and 165 of the Administration of Criminal Justice Act 2015, and under the inherent jurisdiction of this very noble court, I am praying, my Lord, for an order admitting me on bail, the defendant applicant to bail on liberal terms, pending the determination of the invalid charge presently before this court, an order, my Lord, declaring that the continued detention of the defendant applicant, my humble self, in the absence of a valid subsisting charge under a written law in force, is unconstitutional, null, and void, my Lord, and for any other orders that my noble Lord may deem fit to make under the circumstance. This is supported by an affidavit of 9 paragraphs deposed to by Prince Emmanuel Kanu, and also by a written address which I urge my Lord to accept its adoption. Honorable Lord.
Yes. You moved the 3 applications?
I have, my Lord.
Thank you.
Thank you.
The prosecuting counsel, can you rehear to those 3 applications?
May it please your Lordship. The prosecution filed reply to the first motion on the 14th of November 2025. We also filed a reply, a counter affidavit and a reply in respect of the first motion. For the second motion, we also filed a reply all on the 14th of November 2025. For the third one, for the further application for bail, we did not file any counter affidavit. So for the first one, sir, I respectfully adopt the counter affidavit of the prosecution and the written address. And we urge your lordship to dismiss the application because it's a regurgitation or repetition of the well-worn argument that the counts which the defendant pleaded to were unknown to law. It is for your lordship to determine that in other ones. But the one asking for stay of proceedings, my lord, our argument is to the fact that the statute does not permit your lordship to grant any stay of proceedings or injunction. So we ask your lordship to dismiss it. And for the second, we also filed a written address dated 14/11. We adopt it with all respect, and we urge your lordship to dismiss the application as lacking in merit. For the last application, asking for the defendant to be admitted to bail on the same ground that, the counts to which he pleaded not guilty were unknown to law. Again, is a repetition of the old argument. It is for lordship to determine whether the laws were valid, whether his plea was valid, and whether he is answerable to the law when he committed the terrorism acts. The terrorism acts he committed was...
Please,
So we urge your lordship to dismiss the application. On the other ground is also to the fact that the applicant has another pending motion filed in March, in April 2025, asking for the same relief, bail. So the latter application with respect, is an abuse. In any event, none of them merits. We urge your lordship to dismiss it.
Please, let's save the time of the court.
We appeal your lordship to dismiss all the applications because they lack in merit and do not deserve any consideration at all. Thank you, my lord.
Thank you, sir. Defendant, you have one or two words to say?
Certainly, my lord, and I'm most grateful. My point is a very simple one, my lord. Very, very simple. My charge sheet, as presently constituted, does not reveal or disclose any written law in Nigeria as at this very morning.
Thank you.
It doesn't exist, my lord. And very finally, I think it is very, very important that I allude to what my lords...
Please, defendants, at this point, you won't go and make references. I just ask you to reply on point of law.
It is, my lord. I'm trying to explain exactly what the point of law is all about. We respect what you have just said.
Yes, let me hear the point of law.
My lord, I cite Eze v.
I'm coming. Consultants, you may guide him properly. Thank you. Let the consultant sit with his client. Or do we have all the consultants? Do they want to sit with their clients? Okay, let me see. Are you here? Mandela, you're here. Opara is okay. Where are the others? Ejiofor, where are the others?
I said, don't touch me. Don't. Let him go by himself. Mad people. You don't know law. Show me where it says you can wear my right for like this. Show me the law. Show me the law. I want to show me the law.
will be the ideal place. So I'm urging your Lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your Lordship, and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. Malala, I want to thank you. I want to appreciate you on behalf of my colleague, Adebayo Ojo, and Suraj Saida. We're grateful to your Lordship for a well-researched, a well-reasoned, and a courageous judgment. Thank you, my Lord.
There is no doubt that the convict has waived his right to be present through his unruly attitude, the habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal through his person. Since his consultant is here and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Jimako, do you have any allocutors to make on his behalf?
My Lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me being the member of House of Representatives who represents Mazen Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what will mitigate the sentence. Is our brother. Let us hear you. You tell us your name. We can't, because of your unruly behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umuahia North, and Umuahia South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Mazen Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, my Lord, he's my brother. He's my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. My Lord, I plead for mercy, I plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it is being done to Mazen Nnamdi Kanu, The other people out there also doing more worse than him.
Please,
Sorry, sir.
I asked for a locutor.
Yes, sir.
Please, don't
So, I apologize, sir. So, I want the court to take judicial notice of that this trial has gone on for almost 10 years. Mazi Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. I'm a friend of the court, having come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back. Speaking to you as pressmen, because the profession does not allow me to discuss with you what happened in the inner works of the court. The profession does not allow me to tell people what happened in court. But today, we have come to a final end. Justice has been done. And therefore, Nigerians must, one way or the other, appreciate the judiciary. You remember just last Monday, the president was saying, at any time when Nigeria is in a big trouble or fix, judiciary has always come to the aid to salvage Nigeria. Again, the judiciary has salvaged Nigeria from the claws, from the oppression of the proscribed IPOB. The court has also pronounced death sentence on Eastern Security Network, which was the military wing of IPOB. Today, God has brought an end to injustice, oppression, suffered by our brothers and sisters of the eastern states of Nigeria. They will not be able to sleep with their two eyes closed. What is important is that every Nigerian must consider issue of security as his personal business. When you look away, when you compromise, or when you show fear, you are encouraging the miscreants, the vandals, the criminals, the terrorists to fester. This issue ought not to have festered for that long. Nigeria is our own country. We have no other country we can call our own. Secondly, it is our responsibility as Nigerians to help the government by way of information. You had during the trial information concerning how several heads of human skull were used to bury a scoundrel, somebody who is a criminal. Some just because people were afraid. We all must be courageous enough to confront terrorism, criminality, and all sort of things. I know that, political insinuations or perspective will be put into this matter. I was in court in there when somebody was saying, oh, Yoruba, Hausa, Igbo. We are all Nigerians. We must love one another. We must not compromise the security of the country on the basis of those primordial sentiments. So I congratulate Nigeria today for seeing the end of this, and let it be a warning to those who may think they are bigger than Nigeria. Nigeria is bigger than every one of us. The law is bigger than every one of us. And the law will take its course to deal with miscreants, to deal with terrorists, to deal with criminals. You know, all of us are victims when we keep quiet. All of us are victims when we don't do what we ought to do. Therefore, let everybody be
a Nigerian. Thank you.
Thank you very much for your time. Thank you, sir. Thank you so much.
Excellent.
Okay, please just step back. Please, can we have you now, please? Thank you so much. Thank you. Wait, Honorable.
One for the corner, I got somewhere here.
No, I'm coming to
Well, let's stop now.
Okay.
The lawyers.
Okay, let's just stop, please.
Yeah.
Okay, no, I'll hold the mic.
Are you going to do a count?
Okay, well, are we good to go? Are we good to go now? Ooh. Okay. All right. Okay, now. Okay, please, we'd just like you to react to the judgment that has just been delivered. It's been a long battle from 2015 to now, but your client got life imprisonment. How are you going
Well,
to react?
today we forever live in infamy. Today is the only day I have witnessed a man being convicted for mere puffery, for what he said from his mouth, not what he did with his own hands. The verdict is not consistent with the evidence laid before the court. The sentence is overbroad, cruel, and unusual. How can you convict a man for making mere broadcasts from a location that was never named, and he never tied that broadcast to any single incident of violence, or even someone slapping someone, not to talk of terrorism? You did all this, you didn't lay any evidence. I don't know where this whole verdict can be grounded in law, logic, or facts. We disagree with the judgment vehemently,
Yes.
and we are going to fight it from here onwards until justice is done.
Yes. There's no justice yet.
We suspect the judgment is not based on law. It's not based on facts. It's based on politics. It's based on some tribal, primordial sentiments. Just because Nnamdi Kanu is Igbo. An Igbo man has become the person in Nigeria that should be trampled upon. I'm not saying this because I'm Igbo. I'll say it for the Hausa or Yoruba who gets trampled upon. But today we saw an Igbo man being trampled upon, and by God Almighty, we are not going to allow it.
It will not stand.
It will not stand. Nobody is going to trample on me. Nobody is going to trample on Nnamdi Kanu. Nnamdi Kanu is not a terrorist. He's a man that was pursuing change. To pursue a separate nation of yours is not a crime. So in Nigeria today, if somebody says, don't be silly, you get convicted. Nnamdi Kanu may broadcast, and so what? And you convict him for terrorism, for mere words in the Federal Republic of Nigeria. What kind of precedent is being laid? So from here, we are heading to the Court of Appeal. The Court of Appeal is the only court in this country, or the next court in this country, that sits as a jury. We are going to approach the justices there to check out what happened in court today. And we are pretty sure the justices will agree with us that today was the symbol of the travesty of justice that everybody has been suspecting all along. If the Court of Appeal disagrees with us, we head to the Supreme Court. But by God Almighty, Nnamdi Kanu is not going to stand convicted.
Not at all.
Is going to get overturned. Thank you.
Excuse me.
Thank you.
Please, I want you people to get something right. I want you people to get something right. First of all, I want to talk to the Igbos that nobody should take laws into your hand. I'm assuring you, this judgment is predicated on anger. Thank God that the judgment was extreme life and everybody watched it. You will see the anger in delivering the judgment. And it's not predicated on law. Now, I also want to let you know that this charge, that the investigation that gave rise to this charge was not investigated, because Nnamdi Kanu's purported statement was rejected by this court.
And they did not tender any document as investigation report. That is to say, the investigation was not, the offense was not investigated. Having said that, also something that happened in court today, Nnamdi Kanu filed a matter in court of appeal. And he is asking my lord, that particular matter I filed in court of appeal anchored on this particular issue. Please, can you just suspend this judgment? Let court of appeal direct what to do. My lord refused. Now, on the issue of anger, you journalists will bear with Nnamdi Kanu that government, Nigerian government and the judiciary are not fair to Nnamdi Kanu. What do I mean? Nnamdi Kanu was given judgment by court of appeal. Federal government refused to comply with that judgment given by court of appeal until after 8 days before they appeal against it. When we get to the Supreme Court directed prosecution what to do. Amend this particular charge. Nnamdi Kanu was saying that, please, can you amend this charge? They refused. With the combined effect of all this, I'm assuring you that this judgment will not stand. And the court of appeal will do justice to it. Now, I also want to plead with judiciary. Nnamdi Kanu is representing himself because the court has given the prosecution a blanket order to detain Nnamdi Kanu wherever they want. They should detain Nnamdi Kanu where you have access to file his appeal, because he has 90 days to file his appeal. And the judge said that the judgment will be ready in the next 15 minutes. I also enjoyed the media. We have the record of proceedings from the day the matter came to this place till today. I want you to check the record of proceedings and evidence tendered, reconcile it with the judgment. Now you now see what we are talking about. You are bringing British into this matter, bringing America into this matter. You are now trying to so that the British and America will be against Nnamdi Kanu. Something that was not an issue, that was not ever tendered, that was never given evidence on, and you are raising the issue. So this is a judgment against the Igbos. This is a judgment against the good people of Southeast, and it's because of Nnamdi Kanu is an Igbo. You cannot give this kind of judgment to a northerner. You cannot give it to a southwesterner. You cannot give it to another tribe in Nigeria apart from the Igbos. And we are going to start against it because it has happened in this country against some other persons, including Abiola. The Igbos join hands together to fight against it. Why should it be our own time and everybody's sitting akimbo? It's unfair. Thank you.
Okay. Sorry, excuse me.
Justice James.
We did.
Well done.
Thank you. It's a crazy day, man.